My client Lisa asked me yesterday whether her ex-spouse had to pay half of her debts, including the $10,000 she owed on her MasterCard and the over $15,000 she still owed on her car loan. That's a common question I get from my clients, and it's a great question. Hi, my name is Thomas O'Malley. I'm an experienced family lawyer in Durham region and the GTA. You deal with your debts in several ways in your separation or divorce. When you're married, you're allowed to deduct the amount of your debts on the date of separation from the value of your assets when you are calculating your net worth for the purpose of dealing with the property claims in your separation or divorce. However, you're still legally responsible for your own debts, even though you can deduct this amount from the value of your assets. For example, if you owe $10,000 on your Visa credit card, you still owe that money to Visa, regardless of your separation or divorce. A separation or divorce does not make any difference to a third-party lender, such as banks and credit card companies. You can undertake or agree to pay your spouse's particular debt, such as a loan, in a separation agreement or court settlement. However, the third-party lender will still pursue your spouse for that debt if that debt is not getting paid off, since that debt is still legally in your spouse's name. It is a serious misconception or myth that your spouse is responsible for half of your debts when a relationship or marriage ends. Each person is still legally responsible for paying their own debts, regardless of a separation or divorce. As I mentioned, you can agree to pay your spouse's particular debt in a separation agreement or court settlement. However, this agreement is only between you and your spouse. A third-party lender is not bound by this agreement. If you're not paying this debt, a third-party lender will still pursue your spouse for paying that debt off, since that debt is still legally in your spouse's name. However, your spouse could then legally pursue you for paying that debt, since you're not paying it off, pursuant to the terms of your separation agreement or court settlement. When you and your spouse have joint debts, such as a mortgage on your home, you are both legally responsible for paying that debt. When a spouse buys out the interest of the other spouse in the home, a common term in the written agreement is that the spouse must refinance the mortgage so that the current mortgage is paid off and the other spouse is no longer on that mortgage and no longer responsible for any mortgage payments. In other words, the spouse no longer has any legal responsibility for paying off a mortgage on that home. This also applies to people living in common law relationships, so that each spouse is legally responsible for paying their own debts, and both spouses are both legally responsible for paying off any joint debts, such as a mortgage on a home. In summary, you're responsible for your own personal debts that accumulated during the relationship or marriage. Examples of these personal debts include monies owing on personal credit cards and personal loans, such as car loans. If you have any questions about your separation, divorce, or family law case, and you'd like our help, feel free to contact me on my Facebook Law Office page, that's O'Malley Family Law, or call me at 905-434-8837, and I'll point you in the right direction. Please make sure to share this important information and video with your friends, family members, and coworkers.